This is case number D-14-504666D. Howard King, are you Mr. King?
Yes, sir.
And you're present, good morning to you, with counsel?
Yes, good morning, Your Honor. Adriana Rincon-White, 10973, appearing for Mr. King in an unbundled capacity.
Good morning, Ms. White.
Good morning.
And appearing by telephone is Darla Rose King. Ms. King, are
Yes.
you present?
Yes.
Okay. Can you hear me okay?
Yeah.
All right. This is a, tell me, counsel, please.
Yes, Your Honor. What brings us here, my client had filed a motion for change of custody. The court heard that in March of 2016 and continued the hearing to today for two reasons. One, Ms. King was supposed to get a drug test, which she did, and the court was going to review CPS records from Ohio, where mom and the children currently reside. I don't know if the court was able to do that. I know Judge Brown isn't here, obviously. The third reason why we're here is that mom filed a motion to set aside the decree that was filed February 25th, 2015. She filed her motion March 22nd. My client obviously had retained me to represent him on that. So those are the three reasons we're here. Our objection to the motion to set aside is the fact that the decree, and I misspoke, I said February 25th, it was actually filed April 23rd, was filed April 23rd, 2015. If Ms. King is alleging in her motion that she did not sign the decree, if the court looks at page 8 of the decree, it was signed by her. She just signed in the part that said you were supposed to print your name. She signed it in the print section instead of in the signature section. Even if she says I didn't sign it, that's not my signature. On page 7, which is of the parenting agreement attached to the decree, is her signature again agreeing to the custodial issues. And it resembles the signature. So not only did she sign the parenting agreement attached as an exhibit, but she also signed the decree of divorce, assuming that the court says that's not her signature. I reviewed the hearing from February 25th, 2015, where Mr. King was present, Ms. King were present as parties, and the court asked at timestamp 9/40/14- through 17, the court said, do you have assets and debts? The defendant answered, we just want a divorce. The court asked again, and at timestamp 9/40/28, she said, we gave everything away. So twice, herself, in open court under penalty of perjury, because they had both been sworn in by the court, she says that they do not have assets. Now she's trying to set aside the decree that she did sign, that she did represent to the court that they didn't have assets. She's trying to set it aside on the basis that they do have assets. It's been over a year that these parties have been divorced, and she hadn't raised it before. Now she's alleging that there's a 401k, that there's a retirement account. My client is a member of a union. He does have a pension, but it's not vested because you need to have 5 credits. He only had 3. She alleges that there are cars. Her car was repossessed. My client's car was repossessed. So we are opposing, in summary, for several reasons. 1, she signed the decree. 2, she signed the parenting agreement attached to the decree. 3rd, she was in court February 25th, 2015, and she stated that she didn't have assets. And 3rd, even if you did set aside the decree, for what reason? There are no assets or debts to divide here. So we are asking Your Honor to deny her request to set aside the decree for that reason. Pursuant to NRCP 60B, in order for the court to set aside a decree, there has to be mistake, fraud, undue influence, something of that nature. The fact that things were not included in the decree that she said did not exist is not a basis. She was here. There's no ground under NRCP 60B for the court to set aside the decree.
Thank you. Ms. King, you've heard everything that Ms. White just got through saying?
Yes, Your Honor. The thing is when we signed the parenting agreement, we did sign the parenting agreement. He also offered to help me, and he also offered to take the kids. He has not once. He's taken them one time. He also, I have text to tell him not to turn in that parenting agreement, and he said he wouldn't. He did anyways. I have those texts. I can screenshot them, fax them to you. I have them on my phone. As far as anything else,
All right.
the 401k, the pension, that wasn't even mentioned in the divorce. We did not have a final hearing for that divorce at all. They just signed off on it, and we didn't get to go in front of a judge to, speak what we needed to speak.
But you were present in court, Ms. White said. Do you remember being in court?
Yes. In February, I was in court. We were supposed to go back to court again, and they just canceled the court date out.
Okay. Anything else, Ms. White, in regards to the motion to set aside the decree?
Regarding the motion to set aside the decree, in just response to hers, text, NRCP 60B is pretty strict. It says the reasons why you have to set aside a decree: mistake, fraud, nothing having to do with I told them to not turn in the decree. She has known she's been divorced for this long. So why did she take nearly a year to set it aside? And doesn't even state that there was fraud, that there was mistake. She says she told him not to turn in the decree. That's not a basis. Your Honor, they were here February 25th, 2015 with Judge Steele. The matter got trailed. They returned. They went to mediation the same day. She said, we just want a divorce. And she went on to say that she just wanted a divorce because she already had her flight to Ohio. That was a final hearing. The court even, Your Honor, rejected their custodial. The parties initially told the judge they wanted ex-custody arrangement. The court rejected it and sent them to negotiate. So she was here. She knew what she was doing. In fact, she even changed her name on reliance of the decree. The decree says restore to Hawks, and she did it. So the decree can't be good for one thing and not be good for another. There's no basis under 60B to set it aside.
And you, Ms. White, signed the parenting agreement, correct?
I didn't. I wasn't his attorney.
Sorry,
the parties did.
Ms. Kate.
Yes.
Ms. Kate.
Yes, I did sign the parenting agreement.
All right. The motion to set aside the decree is denied. I do not see any reasons to grant the motion. If you feel a need, there's always changed circumstances, but you can file a motion in that regard. But no, the decree is the decree. You were served, you were present, because, I don't know, because you think you omitted something, that is not grounds. So the motion to set aside the decree is denied. All right, now, what do we have?
The other issue is, obviously, I'm not sure whether the court even got the records from Ohio CPS.
I did not. The court does not.
I sent, excuse me, Your Honor, I sent in a piece of paper stating with that a letter from the kids' counselor as well as the CPS worker stating that they was closed. I did send that in.
Well,
I'm going to have the clerk take a look. I do not see, I'm just double checking, any records from CPS Child Protective Services.
what she did send is a letter without letterhead signed by some counselor from Home for Kids or something like that. We are even disputing that that's a counselor. It's not even on letterhead. It doesn't look like anything official. My client had filed the underlying motion for change of custody, and we asked that at this point an evidentiary hearing be set. She moved to Ohio on the pretense that, and she stated it at that February 25th hearing, that her grandmother had given her a house. If you look at the motion that she filed, she lives in an apartment number 1. She's on receiving state benefits. She isn't working. My client hasn't been able to see the children. She has moved twice. The point is that my client said in his motion he wants the children to have stability, which mom is not offering. So that at this point we ask for an evidentiary hearing, Your Honor, on my client's request for change of custody.
Okay. Any comments? I don't have...
Yes, my grandmother did give me a house. However, the house is the electrical work. I just don't have the funds to fix it. And as for a job, I am in between jobs, but I just had my interview yesterday, and I did get a healthcare position at just like home. And as far as living in an apartment, that apartment is family owned. And I thought it was best because of work that my mother, it's easier for her to help me out, and it's easier for me. I did start back at school at eBase Academy, and I've been working on everything. I am in between jobs, but I am to start work next week.
The point of moving to another state, Your Honor, is to the state legislature, and there's case law to support that, is to improve the life of the children. To go home or to go to another state, to rely on family to help you. Why? There's dad here. Dad is employed. He has a good, stable job. He has a home here. The case law is very clear under Schwartz. You are not supposed to move to another state to struggle with the children. You're supposed to move to another state to improve their life. And obviously there is no improvement here. So we ask that you consider my client's case a prima facie case for changing custody, and that you grant the evidentiary hearing so that if mom does live in a family-owned apartment, does have a job, does have stability, she could simply prove it. And if she proves satisfactorily to the court that the life of the children is better in Ohio than in Las Vegas with their father, then that will be the decision of the court.
Well, there you are, Miss King. No.
Your Honor, Howard lives in an RV. He lives in an RV on a lake, and their lives, by any means, they go to counseling. They're in the statement in that letter says they're thriving to do better. My kids are doing wonderful. They're getting better grades. My daughter didn't know how to write her name when she came here with me. She now knows she's reading, Your Honor. I have them in counseling not once but twice a week. I have my son Logan has psychologist appointments. Just for the simple fact that when their dad was high, he used to walk around with guns, and my kids are afraid. So I have them getting tested and everything because when he was high in his house that we lived in, he would walk around with his shotgun. My daughter, when she went down there for summer vacation, he took him out shooting. The gun ricocheted and hit my daughter in the ear. He buys my kids guns, buys them Grand Theft Auto, lets them swear, and this is all things that me and the counselors are working with my kids on.
Speaking of high,
because my son thinks that guns
All right, let's stop.
Speaking of high, the drug test results speak for themselves.
I'm going to set this matter for a hearing. You say you're working, Ms. King. You say you have a stable.
Yeah, I just recently. Yes, I went to the interview, and she's looking.
Listen to me. Prove it. That's what you'll do at the hearing. As a matter of fact, I'm sure that if I checked with the law clerk, I checked with CPS records. I can't find anything in the computer or in the brief. So get that stuff. Get your ducks in order. You can't just come in and say make these allegations, and that's why we're going to have a hearing. So the hearing date will be
September 15th at 1:30.
September 15th at 1:30.
Is there any summer evidentiary hearing available? The only reason I say, Your Honor, is because if it gets granted, we have a school issue, and usually the court doesn't want to change custody in the middle, when it's... That's what it'll be then.
Apparently not. That's it.
September 15th at
1:30.
1:30. Okay, that'll have to do. Thank you, Your Honor.
Thank you. Hang on a second. I got a motion for an order to enforce and/or for an order to show cause regarding contempt. But you know,
My client?
it's on my cover sheet.
Did you file that?
No, she did.
Yes, he refused to pay for a urine test. I went and did the hair test. He refused to pay for the urine test. He actually badgered me to the gentleman that did my hair test and told him I was a crackhead and all kinds of things, Your Honor. The guy looked at me and he's like, man, he must really hate you. And I'm like, yeah, he probably does. He badgered me pretty badly, too, when he had to pay for the drug test. And then he refused to pay for the urine test, Your Honor.
And so you, based on that, you filed a motion for contempt?
Well, because I didn't want to get in trouble for not taking a urine test,
You paid the test.
for him not paying for it.
But the order was, my client was supposed to pay for the test. Obviously, we got results. You paid for the test. And the general rule is that if somebody tests dirty, they reimburse, which we won't even pursue at this point.
The
So,
motion for contempt is denied.
thank you.
Thank you, Your Honor.
Ms. White, get me an order
Yes,
in
my
regards
client,
to
I'm
the
unbundled,
contempt.
so I'll have my client prepare it. Thank you.
Your Honor, so I have to